Greetings and welcome to another lecture in Introductory Psychology. This one involves psychology and the law, which is a very interesting question for a lot of people. If you watch any of these many law and order shows, whether they are literally law and order shows or things like CSI, that sort of stuff, NCIS, they're probably always mentioning things like insanity and the insanity defense and competency and such. Or if you watch the news, you may also hear those terms used in there. Now, the big question, of course, is what exactly do those mean? And that's what this lecture is about. The first thing I want to point out is the difference between the terms mentally ill and insane. I'm very careful in my classes and on these recordings to not use the term insane because it's not a psychological term. It's a law term. Okay? Insanity is defined by lawyers. Mental illness is defined by psychologists and psychiatrists. So when I talk about insanity, as I said, it's a legal term. It's found in legal dictionaries, not so much in psychological ones. Now, when a person is put up for trial or is going to be put on trial for a crime, one of the first things that needs to be done, although for most cases it's a formality, is to determine whether or not the person is competent to stand trial. The question of competency, which is also known as fitness. Is the person fit to stand trial? Now, competency has to do with the person's mental state at the time of the trial. Not the crime, the trial. And basically, competency is decided by the judge who is in charge. And if a person is competent to stand trial, it means that, first of all, they need to understand what is happening. They need to know who all these people are. The judge, the other lawyers, the jury if possible. I mean, all of these people, they need to know who they are. They need to know why they're there. And they need to understand what the consequences of this could be, what the outcome might be. And they also need to be able to freely choose whether or not to help their attorney. People aren't forced to have an attorney. But if someone, for instance, has a mental illness like schizophrenia and they're paranoid and they're sure that their attorney is out to get them as well as everyone else, they're not going to be competent to stand trial. So like I said, for the vast majority of defendants, this is an automatic sort of thing. Yes, they're competent, let's move on. But it may be necessary, if there is a question of competency, for the defendant to be examined by a psychologist or psychologists. And these practitioners will then decide whether or not the person indeed fits competency. Now, if the defendant is not competent to stand trial, what will happen is they will be hospitalized and treated against their will, if necessary, until they are competent, and then they will be put on trial. We're hopefully not going to put people on trial who are not competent. And this is one of the times, by the way, that people lose the ability to say no to treatment. Otherwise, a person is treated or treats themselves very much on their own terms. And if they decide to no longer take their medication or they decide to no longer see their doctor, there's not a whole lot that can be done about it. But if a person has committed a crime and is being treated for competency or for other reasons perhaps, then they pretty much lose their option to say no. Now, by the way, competency, sometimes if people are never found competent to stand trial, it turns out that they will never be put on trial, which means that they will never leave a hospital or a prison hospital, which, depending on what you mean by what you intend to have happen when someone is sent to jail, sort of serves the same purpose as going to jail. And if a person takes longer to be found competent than the maximum sentence for their crime, whatever it might be, let's say the maximum jail sentence for that crime was 18 months, but it took 2 years for the person to become competent, they will usually not be put on trial. And they will be released, but they will have a file with a great big note in it that says, this happened, so if it happens to happen again, they're going to probably throw the book at the person. Okay? Sort of 1 strike and you're out kind of thing. Well, 2 strikes, actually. Now, when it comes to insanity, like I mentioned, insanity is a legal term, which is why it's a very long and complicated term. Now, whether or not someone is found insane is decided by the jury after the trial. So competency is before the trial, insanity is during the trial. Now, the rule that is used by most of the states that have an insanity defense, and not every state does, by the way, in the U.S., Montana, Idaho, and Utah do not allow the insanity defense. You can say and prove that you were not in your right mind during a crime, but that they can't find you not guilty by reason of insanity. They have to perhaps use that as other mitigating evidence toward your particular sentence. But at any rate, the rule that is used for the most part in the United States is called the McNaughton Rule, named after Daniel McNaughton, who in the middle 1800s was described in the papers of the time as a deluded Scotsman who was absolutely certain that the Prime Minister of England was out to get him. So he figured the best thing to do, instead of waiting around for the Prime Minister to get him, would be to get the Prime Minister first. And so he took a couple of shots at the Prime Minister, missed him, but killed one of the Prime Minister's aides, was put on trial, was found not guilty by reason of insanity, and the arguing hasn't stopped since. Here's the McNaughton Rule. It basically has two parts. The first part is that the disorder prevents a person from knowing right from wrong. For instance, if a person has paranoid schizophrenia and they're certain that everyone is out to get them and they kill people because they're certain everyone's out to get them, one could argue that they don't know right from wrong, because they don't know the right behavior versus the wrong behavior, and they do the wrong thing. Or that poor lady in Texas that drowned her children in the bathtub because she was absolutely certain that she was saving them from this hell on earth and putting them into a better life to come, would be unable to distinguish right from wrong. Or when they don't know what they are doing. Sometimes it appears that people can become so head up because of some sort of traumatic event or what is going on or their own psychological makeup that they simply snap. And they're not in control of what's going on. They may do incredible amounts of violence. Just not thinking about it. They almost black out and do these horrible things, and then they might indeed, snap right back and be perfectly fine. Which is why insanity and competency are different. A person may be found competent to stand trial and yet be found insane. Because at the time of the trial they might be absolutely fine, but at the time of the crime they might not know what they're doing or not be able to control what they're doing. So it's a rather broad rule. Although I have to admit, I got to tell you that the insanity defense is not used often at all. This is not a common thing, unlike what you might think if you watch TV. It's been estimated that the insanity defense is only used in less than 1% of cases. Okay, I mean less than 1% of trials have any hint of the insanity defense. And in those less than 1%, only about 1 in 4 are successful. It's difficult to use the insanity defense because it may be broad, but it's also very vague. And in addition, a lot of people are not really thrilled by the insanity defense, because what happens with the insanity defense is, if a person is found not guilty due to mental illness, is that the person will be hospitalized, they will be treated until they are no longer a danger to themselves or to others, and then they will be released. The idea being that we do not hold people in prison and hold them responsible for something they did when they were not in control of themselves, when they were not in control of their behavior because of a mental illness. Now, if the person drinks a lot of alcohol or takes drugs and does horrible things, that's a whole different kettle of fish there. Okay? But this is when a mental disorder, not drugs or alcohol, makes a person unable to... We're not going to punish people for stuff they did when they weren't in control of themselves and they had no control over being in control of themselves. But that makes a lot of other people very unhappy. Because it is indeed possible for someone to snap, kill a whole bunch of people, snap back, and then, having been found not guilty due to mental illness or not guilty by reason of insanity, be hospitalized for 3 months or 6 months or maybe a year and then be let go after having killed however many people. Now, this isn't likely to happen, because in order to be released and be considered no longer a danger to themselves or to others, you usually have to have a number of psychologists agreeing, and it's a difficult thing if a person has been committed against their will often for them to be let go, simply because a person's mindset is indeed so difficult to be able to interpret, so difficult to be able to predict. By the way, the insanity defense works best when people have already, prior to the crime, been diagnosed with a mental disorder. It's a lot easier then for people to believe that the mental disorder might have caused the problem, as opposed to just sort of spontaneously appearing out of nowhere. A lot of people are very suspicious Because, like they said, they don't think that someone who kills a whole bunch of people should be free after a year, mental disorder or no mental disorder. Okay? If you kill this many people, you should be punished. And that's when we run into a couple of different and rather conflicting verdicts. As I said, not guilty due to mental illness means that a person will be hospitalized, treated till they're no longer a danger, and then released. But a number of states have gone to another verdict called guilty but mentally ill. Now, what happens when a person is found guilty but mentally ill is that once they are found that, they are sent to a hospital, treated until they are no longer a danger to themselves or to others, and then they are sent to a prison to serve the remainder of the sentence for their crime. So if a person kills a bunch of people and they get found guilty but mentally ill, 25 to life, what happens is they go in for treatment. If they're better in a year or two, they still have to serve the next however many years in prison before they can be eligible for parole. And this tends to piss off a whole different facet of people. Why are we punishing people for things that they did when they were not in control of themselves or control of their behavior? A lot of people think that's unfair. And then a lot of other people think, well, why are we letting murderers walk the street simply because they weren't taking their medication and now they are? And as I mentioned before, when I talked about the McNaughton Rule and Daniel McNaughton, the arguing has not stopped. This is something that lawyers and psychologists alike have a tendency to debate, is how much should we consider a person's mental state? How much leeway should we give a person who has a particular disorder? What if they never had symptoms of it before? What if a person deliberately goes off their medication and kills somebody because they didn't take their medication? Should we treat them more harshly? And we simply do not know all of these permutations. I really suspect that I don't know them anyway, because this is traveling over into the law end of the spectrum, which, other than rather devoted viewing of the original Law and Order, I have very little background in. And by the way, Law and Order makes stuff up. They admit it. So it's not exactly the best background. But as I mentioned before, now you have some idea of the difference between competence and insanity and how they're used and what